Welcome to High Street Matters, a podcast from Bira, the British Independent Retailers Association. My name's Steve Dyson, a journalist who's interviewing business owners and experts about issues that impact independent retailers today. In our latest episode, High Street Matters is going to take a detailed look at forthcoming changes to employment law and how these could impact independent traders and what businesses need to do to prepare for them. I'm going to be interviewing Gerry O'Hare, the Legal Director of Employment Law Specialist Worknest, and John Jones, Managing Director of Philip Morris & Sons, a homewares and country clothing store based in Hereford. Also joining us will be Andrew Goodacre, the Chief Executive of Bira. I want to speak first to Gerry O'Hare, the Legal Director of Worknest, who are experts in employment law, HR and health and safety. They also provide a legal helpline for Bira members. Gerry, can you please give us a general outline of the forthcoming changes in employment law and what they might mean for independent traders?
Sure. Thanks, Steve. Lovely to be here. Thanks for having me. Well, it's no underestimate to say that the UK employment law landscape is going to undergo a tectonic shift over the next 2 years. Employers are basically staring down the barrel of generational changes. And so it's going to be more important than ever for them to try and stay ahead of the curve where possible. So here are some of the headlines. The introduction of a day one right not to be unfairly dismissed. And this is a biggie, Steve, and it will give an estimated 9 million employees additional protection. Changes to zero-hour contracts, a stronger duty to prevent sexual harassment in the workplace, statutory sick pay reforms, and the extension of time limits for bringing employment tribunal claims from the current 3-month period to 6 months. I should say that this is a non-exhaustive list, but I think it's fair to say that there's a lot coming down the line for employers to grapple with, Steve.
No, thanks, Gerry. Let's go to Andrew Goodacre, the Chief Executive of Bira. Andrew, some of those changes sound quite good news for the workers themselves, but what are your first thoughts on how they might impact your members?
Well, I think any employer hearing a summary that these are generational changes, which I agree with that statement, by the way, they are generational changes, automatically thinks negatively about the changes that are coming their way. Employment law is already a complex area. Most employers are responsible. Most employers want to do the right thing, and most employers respect the rules around which they are governed, and want to treat their employees fairly. I think what we're seeing with these changes are they're not just addressing some loopholes that have been exploited by bad employers. They're actually changing some things that really don't need changing. And if we're not careful, whilst we want to be fair to employees, the danger is that the balance of power switches to the employee, and it becomes increasingly difficult for an employer to employ.
Let's have a listen to what one of your traders thinks about this. Also joining us today is John Jones. He's managing partner of Philip Morris & Sons, a homewares and country clothing store based in Hereford. John, you're also Bira president at the moment, so you represent a lot of members out there. What's worrying you on the front line about these changes?
Ultimately, it comes down to the viability of businesses, my own and the rest of the Bira members, that we're already dealing with this huge new tax burden that rates and national minimum wage, etc., has put onto us. And then we've got essentially a huge raft of changes to deal with in this. There's so many potential pitfalls that however responsible you are as an employer, however well-meaning you are towards your employees, however well you want to treat them, you can fall into any number of holes here. And as small businesses, we haven't got HR departments, we haven't got the resources to be putting hundreds of hours into making sure that we're ticking every box on this, dotting every I, crossing every T. And so the burden that it is putting on businesses means that they're not doing what they need to be doing the day-to-day of making money, but instead they're taking care of all of these issues that call the viability of the business into question.
Yeah, and just to expand on that a little bit, John, of all the changes, what stands out in your mind as the most frightening for you as a trader?
One of the biggest ones is definitely the day one in rights that, with the best will in the world, we can all make mistakes at interviewing and in our recruitment process. And if you've then got a lengthy process to unwind that when you've made the wrong decision, it's a big burden on the business, and that can be disruptive, not just with that employee that you've made a misjudgment on, but affecting across all of the rest of your employees and so on as well. So it's a huge risk if you get that sort of situation where you've got the wrong person in your team.
Okay, well, let's go back to Gerry at Worknest. Gerry, you heard John speaking there and Andrew before him, and we're talking about a huge raft of changes here, and that seems to be one of the concerns. There's just so many potential pitfalls, and it's going to be so time-consuming for independent traders. And specifically, John talked about the potential mistakes that anyone can make in employing the wrong person, whether they end up not being a team player or in some cases dishonest or whatever it happens to be. And then there seems to be a new and difficult challenge to unwind that employment process. So perhaps you can just talk us through, Gerry, in terms of your response to those concerns, specifically on that initial employment, which might be a mistake, but also on the wider raft of pitfalls out there. What can Bira members start to do to address these things?
Yeah, thanks, Steve. And I do think John is right to be concerned, as there's no hiding from the fact that many of these new laws and rules and regulations is going to make running a business more burdensome. There's unfortunately no shying away from that. Let's start, first of all, with the concern around employing someone who turns out to be the wrong person for the business. Mistakes can and do happen, absolutely. As things stand, just for listeners, they'll already be aware, but as things currently stand, only employees who've been employed for 2 years have the right to make a claim for unfair dismissal. But the Employment Rights Bill, and everybody's heard of that, I'm sure, will abolish the 2-year qualifying period, making unfair dismissal a day one right. Now, that being said, during what's known as, and I'm going to be a little bit technical here, what's known as the initial period of employment, so basically a fancy way of saying a probationary period, employers will still be able to dismiss employees more easily through a light touch process. What that light touch will look like remains to be seen, because we're still awaiting further guidance from the government, but it will likely at least mean meeting with the employee to explain to them why they're not suitable for the role. So there will actually be a mechanism to deal with employees who are short serving if they aren't working out. You will just have to do more than you currently do in order to stay the right side of the law.
Okay, let's bring Andrew Goodacre back in for a moment. Andrew, initially, does that make sense what Gerry said? And perhaps you can then just take us through a couple of the other priority concerns that your members have.
Yeah, I think it does make sense what Gerry said there. And what's a little bit encouraging for us all is that there's a sign in Gerry's comments there that government are willing to listen. That the overall statement was okay, day one rights from day one, and you cannot move people on easily within the first 2 years anymore. But having listened to sectors like us and people like us talking to them about the impact on employers, then that there is a degree of listening there coming through. And that, I know we'll touch on it later on, I'm sure, but that's important that we continue to consult and inform government of what the likely unintended consequences might be of some of these changes. In terms of other aspects of the bill coming through that are real concerns, I hear members talking about flexibility. Retail, by its very nature, is a flexible business. Whether you're a seasonal business, whether you're a tourist business, whether you are a 9 to 5, 6 to 9 retailer, it really varies a lot. And so flexibility or the perceived lack of it is a concern. It's not just day one rights in terms of employment rights and the ability to move bad employees on, but it's also about day one sick pay, day one other benefits that come into effect as well. And that's seen as a potential huge increase in cost, because at the moment, I'm sure Joe will touch on this, I think it's the first 3 days of an absence period due to illness is there's no sick pay can be claimed, but it will be from day one. And in a way, I'm sure good employees don't do this, but there are employees who will see that as an option if they're not feeling quite right, or if they've been out for the night out and got a bit of a hangover, they don't come in, but they're still not losing any money, or they're getting some money for being absent, which they wouldn't get at the moment in time. And that is a concern for employers. They're concerned that their absence rates will increase as a result of that right coming through there. Those are the two big areas that I'm hearing from members: increased costs due to benefits from day one, and a lack of ability to be flexible with employees rather, to reflect the nature of their trading in their business.
Gerry, let's hear from you on those 2 points. I mean, I've got some more specific questions from Bira members, but let's answer those first in terms of the immediate sick pay elements, and also the general feeling that flexibility is needed in the retail area.
Yeah, thanks, Steve. Some very good points being made there by Andrew on behalf of, I'm sure, businesses up and down the UK. So dealing, first of all, just with statutory sick pay, as listeners will know, currently SSP is payable from day 4 of sickness, and employees also need to be earning above the lower earnings limit, which is currently £125 in order to qualify for it. But the bill is making quite sweeping changes to that, so that SSP will become payable from day 1 of sickness rather than day 4. But not only that, the lower earnings limit will also be removed, meaning that all eligible employees, regardless of earnings, will be entitled to SSP. And as a result of very recent amendments to the bill, those earning less than the lower earnings limit will be entitled to SSP at a rate of 80% of weekly earnings. And so, frankly, this is going to be a very costly change for employers, Steve. There's no shying away from that. And I think Andrew is quite right. I'd like to think this isn't the case, but it probably will mean that businesses up and down the UK will see more people going off sick. Because whilst they're not getting a lot of money, they will be receiving some money from day 1 of sickness.
Yeah, just listening to that, John, how does that make you feel as an employer who obviously occasionally will need to employ new people, but now you're faced with that immediate cost? How will you cope with that?
Yeah, well, some of it does seem almost ridiculous that they're getting that money from the start at 80% for those low earners. I get where the government's probably coming from to protect the lowest earners, but it's also meaning that Saturday people that we often have, it's their first job, they're still at school, perhaps in an age group where they're likely to have a hangover from having too much the night before. Suddenly, actually, they're still entitled to 80% of their pay. And, they're living at home. These aren't the people the government needs to be protecting with this kind of rule. And we've got this kind of situation in where we're going to have to be paying them their sick from day 1. And it's more difficult to get rid of them if we have made that mistake we're talking about earlier. So sort of, how does it make me feel overall? It's sort of, concerned about the overall burden of doing business, as we discussed earlier.
Yeah, I understand that, and maybe I can put to Gerry that concern from John, but also a specific question from another Bira member, which came up at a recent hub that Bira had with some of its members about these issues. The Bira members' concern was, what are exactly the financial implications of immediate statutory sick pay? I know, Gerry, that you said that from day 1 they would be earning up to 80% of their pay in terms of SSPs, so statutory sick pay. So what does that equate to in terms of per worker?
I don't have the financials to hand of that, Steve. All I can really say is that it's going to be extremely significant, not least because the removal of the lower earnings limit will basically enable 1.3 million people, additional people, to access SSP. So basically massive implications.
And that, Andrew, just thinking about how many people are involved there, that can't be allowed to go ahead without any kind of influence from you guys, can it?
Well, we have given a submission on this to the government. The government is going through a consultation period on key aspects of the bill like this. I don't think we're a lone voice. Nearly every employer, every sector I speak to is really concerned about this aspect. And it's not being cynical. It's not about wanting to mistreat younger people or people doing less hours and so on. The harsh reality is that if the ability to take a day off exists, and let's not forget, we don't have to go to a GP anymore. That's not been the case for a long time. You can self-certify for 7 days. But if the ability just to take a day off, still earn money, and relax and recover, doesn't feel fair on the employers, because it's not just the cost of the 80% pay that you're paying. You may have to cover that shift. You may have to cover that person's absence by bringing someone else in. You may have to sacrifice by closing early or opening late. There's other hidden costs of that person choosing not to come in because it's suddenly easier to stay away from the workplace because they may not be feeling 100%. So yes, there'll be a lot of consultation on this, but this government seems determined to push this one through.
Okay, well, that's the issue of sick pay, which obviously is huge, and hopefully the lawmakers are listening to the concerns here. Let's go through a few of the questions, because they're quite good specific questions which Bira came up with from its meeting and hub that it held with its members. One of the traders said, regarding day one workers' rights, if a new starter is 3 hours late on day one, can't I just dismiss them as they are on a probation? That's the question, Gerry. What's your reply to that as a Worknest expert?
Yeah, thanks, Steve. So, as I mentioned earlier, there will be that light touch mechanism giving employers more flexibility to dismiss fairly in the early days of employment. And so, in this example, while we're yet to see exactly what that process will look like, I do anticipate that they'll still be able to dismiss this person, but they'll just need to meet with them in the first instance to hear what they have to say before doing so.
Okay. Another question which is kind of related to that, because it's talking about those early starters in terms of people in the first few weeks and months of their employment. Another Bira member said, would I not just be better to start everyone on a 3-month fixed term contract so that it's easier to let go of them if I'm not happy?
It's unclear how day one unfair dismissal rights will apply to fixed term contracts, as the Employment Rights Bill is actually silent on this. What I will say, however, is that ending a fixed term contract still amounts to a dismissal in law. And so there is a risk that full unfair dismissal rights could apply to a short fixed term contract, including even a one off shift. And so I'm doubtful this is going to be a clever way to circumvent the new law.
What I would say, Steve, I think that what that question shows is already how employers are thinking, how they might find a way around the regulations. And it's often due to shared information they may see on social media or sharing with colleagues on the high street and so on. And I'm not saying it's right or wrong, but I urge caution to people thinking they found a smart solution without checking it through and thinking it through on that basis. And another point I'd need to mention, I think it may apply to some of our members, but if you use things like contract cleaners to clean your store or your office or whatever the case may be, I think, Gerry, I think they're also covered by the same regulations now, aren't they? So you can't change their shift without giving extra notice, etc. Even though they're not directly employed by you, they are in a way still protected because of the nature of the work they do.
Yeah, that's correct, Andrew.
I think the answer that you've covered there is the next question as well. It's a very similar question, and perhaps just confirm that I've got it right, that this is not really possible, Gerry. But one of the traders said, I currently start all new employees on a 3-month probationary period. How will a bill affect that?
Well, the bill doesn't really affect that. And so I would urge employers to continue using probationary periods. I mentioned earlier the initial period of employment. And while we're still waiting to hear what that looks like, we're still waiting to hear from the government as to how long a period that initial period of employment is going to be, but the government seems to be leaning towards a period of 9 months. So what I would suggest is that employers marry up their probationary periods with that initial period of employment so that they're both running in tandem, i.e. they're both of a length of 9 months.
That's quite interesting, isn't it, John? I'm John Jones, who's an actual trader on the call with us. I don't know what your current probationary period is for your staff, John, but if it was as high as 9 months in terms of that initial period in the new legislation, then is that something that you might try and mirror?
It probably would, and we'd be very unwise not to. Currently, we have 3 months probationary period, but we keep things very much under review with people all the way up to 2 years. And if we've got doubts about people as they come towards the 2 years, then we will sit down as a management team and have a very serious discussion as to whether there is a risk for us in allowing this person to go past the 2 years, because perhaps large concerns are going to surface.
And I guess what you're saying, Gerry, is that if that happens, if someone is employed and it's not working out well, it's not so much that traders can't get rid of a poor worker. It's just that they have to make sure they adhere to new guidelines, to new regulations, and do it in the right way with the right kind of conversations in the right order.
Yeah, exactly, Steve. And actually, what John just said there was music to my ears. So thank you, John. That's a very good example of an employer doing things in the right way. So monitoring a new employee's performance, speaking to them if there are any areas of concern and trying to address it. So actually, the new changes that are coming in probably won't be that onerous for John and other employers like that who follow a proper good practice of dealing with relatively new employees. It's actually really to capture those pesky employers, of which I'm sure there aren't many in the UK, who follow no such process and are a bit fast and loose with dealing with new employees.
Yeah, okay, I understand that. So let's just go through a couple more of specific questions which came from Bira members because they're quite interesting. One's a question about flexible working requests, Gerry. The Bira member said, it's obvious to me that my shop needs people 9 to 5, and as it's a shop, therefore, a request to work from home is out of the question. Therefore, do I need to even entertain such flexible working requests?
Yeah, thanks. So, I mean, the right to request flexible working is already a day one right. And there are already 8 fair reasons in the legislation for an employer being able to refuse that request. And this includes, for example, the burden of additional costs or the detrimental effect on ability to meet customer demand. The Employment Rights Bill doesn't change any of this, but what it does say is that an employer can only refuse a flexible working request if it's reasonable for them to do so, and the employer need to explain why their refusal is reasonable in writing. So in reality, employers will still have quite a broad discretion to refuse a request. And then in the example of a retail worker asking to work from home, then this will fall neatly into several business reasons listed in the legislation to reasonably refuse such a request. Does that make sense, Steve?
It certainly does make sense to me. Does it to you, John, as a trader?
Yes, I've yet to have an employee that has one of those roles that they have to be on the shop floor in the warehouse, make that request. Yes, I think if they did, the decision and the consideration period would not be difficult.
Nevertheless, it's interesting though, isn't it? Because when changes to employment law come up, different traders in different situations, some of them might be online traders or part online traders, they have these things come up which start to tax them. Another different question I've got here, and I guess it's because 0 hours contracts are mentioned in the legislation, but the specific request is if an employee chooses to stay on a 0 hours contract, is that in breach of the rules? What do you think about that, Gerry?
Yeah, in short, no, it won't breach the rules as the Employment Rights Bill doesn't actually ban 0 hour contracts. as thankfully there's a realization from government that this type of contract actually works generally well both for employers and individuals. What it does do, however, is it seeks to provide workers with additional protections, such as the right to reasonable notice of a shift they're required to work, as well as reasonable notice of a cancelled shift.
I was just going to say, Steve, in terms of what Gerry's saying there, I think this is an area that, when I mentioned flexibility earlier, it wasn't much about people requesting to work from home. It was more to do with, are they still able to use 0-hour contracts? Especially if employees want to use them. And Gerry's right, and there's a lot of employees who quite like the idea of having that flexibility themselves. And some of the questions I've been asked are about seasonal workers. Let's say you may employ a student at Christmas, you may employ them at Easter, you may employ them in the summer holidays. Can they always be on a 0 hours contract each time? And it's those kind of, not complexities. In reality, it's fairly simple, but it looks like when you hear about change with employment law, it's those aspects that make employers really nervous because they don't want to get it wrong, but they're not sure what the full outcome is yet. And what I urge people to do is to speak to us and to speak to Worknest, but also what I urge the government to do on this is to use those real life examples about a student returning back to work 3 times a year over a 4-week period each time. What is the right contract for that? What is allowed? What isn't allowed? That's what people want to know. They don't want to know the complexities of 0 hours contracts and why it's changing in general or what the concerns are. They just want to know what they can do legally so they can still employ that good worker on those basis, because that person is not available the other weeks of the year due to their other commitments. And it's making sure we don't lose sight of the business need as much as the employee need in this respect.
Oh, that's really interesting. John, as a trader, you've listened to various questions and answers given there, both by Andrew and by Gerry. But as a trader, is there anything which is taxing your mind which we haven't covered up to this point?
We've covered the biggest points that are my large concern, but I'm aware that there are also things on sort of parental leave and care in the bill and harassment. And my concern with those is just making sure that actually I've got all my policies updated accordingly and that I've got whatever training I need to do for the staff in place and all those kinds of things that are just those extra things I need to do to make sure that we don't unwittingly fall into a trap here that something that we perhaps was acceptable previously or a requirement that is new doesn't get missed, because this is such a big bill that there's so much in it that I have this fear of we're going to unwittingly miss something.
No, I understand. That's a good point. Gerry, just in answer to John's specifics there, he talks about parental leave and some changes and also changes in and around harassment. Now, again, as John said, we can't hope to deal with the entire bill in this conversation, but on those 2 points there, what's the summary in your mind of the changes and what traders might need to do?
Yeah, thanks. And John's right. The sheer breadth and scale of this bill is quite staggering. As an employment lawyer, it's quite exciting because it's going to keep me very busy for a good few years. But, I've had sleepless nights sometimes thinking about, what I have to tell employers up and down the UK, because we only act for employers, right? That's the most important thing for us. So sexual harassment in the workplace, there are already some changes in the law last year, putting on additional obligations on employers to prevent it from happening, and further changes coming down the line. Currently, employers just have to ensure that it takes all reasonable steps to avoid sexual harassment. Going forward, employers will have to take all reasonable steps. And it's that word all that is the very tricky one for employers up and down the UK. We don't actually know what the government means by that word all. What extra will employers have to take in order to prevent sexual harassment in the workplace? We await further guidance on that, but that's some pretty scary times for employers. What I would say is, I think Andrew's already made reference to this, is do keep an eye on the Bira website. It's constantly updated and it's got lots of very useful information that we chip in order to make sure it's up to date. And if you're in doubt, don't go on the jungle drums to find out what other people are doing. Come directly to the source. Come to Worknest. We'll be able to help and guide you with the best possible up-to-date advice.
Thanks, Gerry, for that. And a last word from John. As a trader, John, listening to what Gerry said, I know there's a lot more to come out and a lot more detail to prepare for. But as a trader, are you feeling more ready than you did before today's podcast?
Yes, a little bit. Certainly a little bit more informed, and I know that I'm going to have to keep working at making sure I am informed as we get closer and closer to this bill passing and the various dates that bits of it will come in.
Good, that's great, and thanks for joining us, John. And a last word from Gerry as well. I mean, you've discussed a lot of the detail as you know it now, Gerry, but can you perhaps summarise a couple of top tips that you've got for traders like John who are trying to prepare for these changes?
Yeah, thanks, Steve. So the changes to unfair dismissal law will make it more important than ever to recruit the right candidates first time round. And so I'd recommend that employers focus on the effectiveness and robustness of their pre-employment screening, their checks, interview and selection processes. I'd also suggest that employers start to look at how they currently treat probationary periods and get into the habit of following a fair process with evidence of poor performance, much like John described earlier. Managers and business owners will very likely need training, if possible, on how to deal with probationary periods fairly and consistently, and how to spot and deal with the early signs of underperformance and poor attendance. If managers are used to the flexibility of a wait it and see approach with the current 2-year window, then they really need to understand it will not work when the law changes.
Thank you, Gerry. That's really good stuff. And finally, a word from Andrew, Andrew Goodacre, the Chief Executive of Bira. Andrew, the new laws and regulations are not quite in place yet. What are the top things that Bira is still trying to pressurize the government and lawmakers to apply? What are the most important things that you want to make clear to them that has got to be right for traders as well, of course, for workers?
Yeah, so it's a very large bill, this. I think we've all tried to emphasize how much is potentially changing here. And immediately the government recognized that, I think, and decided to almost do it in installments. So they're doing a process of consultations on key elements of the bill, whether it's 0-hour contracts, which has been done, the right to guaranteed hours, which has been done, and I think the notice period given if there's any redundancies, and mainly for larger employers, that has been assessed as well. So those consultation processes go on now and carry on through 2025 and possibly 2026. Most of the changes don't happen till 2026. Some of them are already in there now. Some of them were pre-planned, and some will happen before the end of the year. But most of them won't come into play till 2026. And that gives us the opportunity, as an association representing independent retailers, to keep this conversation with the Department for Business, Department for Employment, and keep talking to the policymakers about the unintended consequences that we see. Absence rates increasing because of changes to sick pay is detrimental to growth in the economy. Overburdensome regulations around employment, increasing costs for employers, is detrimental to growth to the economy. And the reason I stress growth to the economy is because this government has set out its stall to be a government that grows the economy. And it is ironic that a government that also says it wants to reduce regulations and bureaucracy in general introduces the biggest change of regulation and bureaucracy in the most complex area it could do. So we just need to carry on doing that. And the areas that concern us are those areas that we talked about today that really will add cost and burden to small employers. These aren't the people who have HR departments and legal teams on site to deal with issues that come up. They don't automatically refer to that. These are hardworking individuals who try to treat people fairly, don't always get it right, but not out of malice or anything like that. It's just not understanding the rules, or out of frustration they make an error that then costs them further down the line. What I would urge members to do, who listen to this and hear about it, two things really. I've said most of the rules come into play in 26. That is not that far away now. Time goes by very, very quickly. And we're already halfway through 2025. So we need to be careful of not being too relaxed about this. We need to start thinking now what changes might happen. And that's why I endorse Gerry's comments about looking at the Bira website, keeping up to date there. And if you need to speak to Worknest Direct, they can do that. Their number is 0345 4500937, and members can use that directly. But whether they're members or not, I would urge all independent retailers to reach out to the local MP and express concerns about changes that they see coming. And why does that make a difference? Well, we already know that this government may change its view on winter fuel payments because of what it's heard from local MPs talking to the constituents during the local elections. If we can continue to make noise about this from local businesses saying how it will affect their business, how it may force them to change their business, even to close, who knows? I'm not trying to scaremonger, but we need to get this message across that too much too soon is asking too much of these small independent retailers. And I urge them all to contact their local MP, get a meeting if they can, express their concerns about it, because that may well influence the government to make more changes that are less punitive to those small employers.
Thank you for that, Andrew. That was Andrew Goodacre, the Chief Executive of Bira. He was joined today by John Jones, Managing Partner of Philip Morris & Sons, homewares and country clothing store based in Hereford, and Gerry O'Hare, the Legal Director of Employment Law Specialist Worknest. Many thanks to you all for joining High Street Matters today. And thanks to you, our audience, for listening to High Street Matters, an original podcast series for Bira, the British Independent Retailers Association. If you found the issues discussed today useful, you can find and listen to previous episodes of this podcast by simply searching online for High Street Matters Bira. And you can find out more about this and other related subjects by visiting Bira's website at bira.co.uk. High Street Matters. Thanks for listening.